Again, on behalf of the Philippine Bar Association, the Harvard Law School Alumni Association, and the Philippine chapter of the International Section of the New York State Bar Association, I'm pleased to welcome all of you and the other 500 plus attendees to this seminar entitled Continuing Challenges in Enforcement of 2016 Arbitral Award on the West Philippine Sea. Allow me at this juncture to wear my professorial hat by outlining the underlying antecedent facts and events relating to the theme and topic of this seminar or webinar, and situating exactly where we are right now in respect of the continuing challenges in the enforcement of the 1916 arbitral ruling in favor of the Philippines. Recall that in 2016, the Permanent Court of Arbitration ruled in favor of the Philippines, recognizing its 370-kilometer exclusive economic zone, or EEZ, and declaring Chinese 9-dash lines and historical claims on the entire South China Sea without basis, and holding other key features in the West Philippine Sea as falling within the Philippines maritime zone. And this ruling effectively negated China's sweeping claims to virtually the entire South China Sea, including the West Philippine Sea. The arbitral ruling had determined that Panatag or Scarborough Shoal, also known as Baho, the Sinlac or Masinlac, Pag-asa Islands, Parola, Kota Islands, Chigua, and Burgos Reefs are all integral parts of the Philippines. Intelligence sources indicated that about 160 Chinese vessels were still moored in the Philippine waters, particularly in the Kalayaan Island Group and Panatag as of April 20. In fact, there are reports that Chinese vessels had been at Julian Felipe or Whitsun Reef since at least February 2020. And significant numbers of Chinese ships were sighted at the reef much earlier than what was reported in November last year, and that these vessels never really disappeared. The Department of Foreign Affairs recently filed diplomatic notes protesting the continued deployment, lingering presence, and activities of Chinese vessels in the Philippine maritime zones, and the swarming and threatening presence of the Chinese vessels creates an atmosphere of instability and is blatant disregard of the commitments by the China to promote peace and stability in the region, and that the presence of these vessels blatantly infringe upon the Philippine sovereignty, sovereign rights, and jurisdictions. And that verbal note or diplomatic note also insisted that China respect the United Nations Convention on the Law of the Sea, or the UNICLOS, and the final and binding 2016 arbitral ruling that recognized the Philippine Exclusive Economic Zone, or EEZ. Last Monday, or 26th of April, in a strongly worded resolution, 11 Philippine senators, led by our active longtime member of the Philippine Bar Association, former Senate President, now Senator Franklin Drilon, close ranks in denouncing China's illegal and unwarranted incursions into the West Philippine Sea, acts that they describe as, and I quote, threatening the peace and security in this region and the world, adding, and I quote again, neither close diplomatic and political ties nor promise of donations, aids, or loans, whether they actually materialize or not, should be mistaken as acceptance of China's creeping hegemony over our region and country, and no promise of economic largesse, often undelivered, should soften our resolve against these illegal and unwarranted incursions, unquote. And the Senate resolution further stressed and concluded that such blatant disregard of established international law not only has a serious ramification on a rules-based international order, but likewise deprives the Philippines fishermen of livelihood, prevents the Philippines from fully taking advantage of the resources within its exclusive zone, causes irreparable destruction of coral reefs, and serves to militarize the South China Sea, unquote. The UP, or the University of the Philippines Maritime Science Institute, reports that the Philippines is losing a total of about 200 billion pesos due to the China's reclamation activities, and around 644 billion pesos worth of fish catch due to the presence of the Chinese vessels in the area. Meanwhile, our Department of Foreign Affairs Secretary, Mr. Teodoro Locsin Jr., said in a tweet, and I quote, "But the dispute is between China and us until the other side sinks a Philippine vessel, and then it falls under the MDT, or the Mutual Defense Treaty, that obliges the Philippines and the United States to defend each other in the event of an attack." Meanwhile, the Philippine Coast Guard and the Bureau of Fisheries and Aquatic Resources have stepped up the conduct of exercises in the West Philippine Sea, with at least 8 ships conducting such exercises since last week at the Philippine-occupied Pag-asa or Chichu Island, and even Panatag or Scarborough Shoal. Last month, the United States Secretary of State, Antony Blinken, said that Washington, quote, "stands by its ally, the Philippines, in the face of the China's massive maritime militia at Whitsun Reef." And then finally, the European Union called out China on Saturday, last 24th April, for endangering peace in the South China Sea, and urged all parties to abide by the 2016 tribunal ruling, which rejected most of China's claim to sovereignty in the sea. On its part, just to balance off this final narration, China rejected the European Union's accusation in that its ships at Whitsun, which China calls THEW Jiao, had endangered peace and security, reiterating that reef is part of China's Nasia Islands, or Spratly Islands, that it was, quote unquote, unreasonable, or rather reasonable and lawful for Chinese fishing boats to operate there and shelter from the ship, or from the wind, rather, quote. The Chinese also insisted, finally, that China's sovereignty, rights, and interests in the South China Seas were formed in the, quote, long course of history and consistent with international law, unquote, and rejected the 2016 tribunal ruling as, quote unquote, null and void, unquote. The events and developments that I just narrated are unmistakably crystal clear, as they are compellingly unassailable. Thus, unlike the other fora or discussions on the pivotal or seminal issues related to the disputed West Philippine Sea, this webinar today goes for the jugular. There are 3 distinguished speakers from the Philippines, United Kingdom, and the United States, who will be introduced by our moderator shortly, will lend their expertise and perspicacity by providing these audience, now more than 500 of them currently in attendance, the nuts and bolts on how the Philippines may effectively enforce the 2000 arbitral ruling or award in light of the refusal of China to recognize and comply with the ruling of the Permanent Court of Arbitration. And moreover, the speakers alike was expected to propose the remedies available to the Philippines within the rubric of said arbitral award. And hence, as an anonymous writer once eloquently said, and I quote, "If you cannot protect what you own nothing," unquote. And as loosely translated in our native language, kung hindi mo kayang protektahan ang iyong ari-arian o katangian, wala kang tinuturing na pag-aari. Once again, welcome to all to this webinar. And without further ado, may I pass on the floor to our moderator and panelist, Attorney Jane De Castro and Professor J. Batombakal. Jane?
It is amidst this tense backdrop that Attorney Rico has carefully laid out for us, which has even dominated headlines recently, that we welcome our speakers today. We are fortunate to have experts on this field to help us cut the seemingly Gordian knot on the issue of enforcement. To guide everyone on our format, each of the speakers will give their presentations, after which we shall have a moderated panel for questions and answers. So we encourage all of you to type in your questions in the chat box at the bottom of your screen so we can include them in a panel discussion later. Now, let me introduce to you our first speaker, the current favorite sparring mate of the President of the Philippines. Dr. Antonio T. Carpio is the former Senior Associate Justice of the Philippine Supreme Court. Since 2010, he has delivered hundreds of lectures on the South China Sea dispute. In 2015, the Department of Foreign Affairs asked Justice Carpio to present the Philippines' perspective on the dispute before think tanks and universities in 30 cities covering 17 countries. In May 2017, he published his book entitled The South China Sea Dispute: Philippine Sovereign Rights and Jurisdiction in the West Philippine Sea. For his scholarship and advocacy, he has been conferred Doctorate of Laws honoris causa by the University of the Philippines, as well as the Ateneo de Davao University, rather. In 2015, he was named an Outstanding Alumnus in Public International Law by the UP Alumni Association, and in 2017, he was cited as its most distinguished alumnus. Justice Carpio obtained his law degree from the College of Law of the University of the Philippines, where he graduated valedictorian, cum laude, and chairman of the Philippine Law Review. He earned his undergraduate degree in economics from Ateneo de Manila University, where he was editor-in-chief of the university paper. Ladies and gentlemen, let's all welcome Justice Antonio Carpio.
A pleasant morning to everyone. Thank you for inviting me to discuss with you this morning the continuing challenges in the enforcement of the arbitral award on the West Philippine Sea. Let me start by making a clarification. The West Philippine Sea is not the same as the South China Sea. The West Philippine Sea is only a part of the South China Sea, which is the larger sea. Under the 2012 Administrative Order 29 of President Aquino, the West Philippine Sea is limited to the 200 nautical mile seaward area measured from the archipelagic baselines of the Philippines facing the South China Sea. This area includes the territorial sea, the island territories, and the exclusive economic zone of the Philippines in the South China Sea. This administrative order should be amended to include an additional 150 nautical miles for extended continental shelf, for a maximum of 350 nautical miles from our archipelagic baselines where there are no overlapping extended continental shelves from other coastal states. There are two disputes in the South China Sea, the territorial dispute and the maritime dispute. These two disputes are different. The territorial dispute refers to the dispute over the sovereignty or ownership of the high tide geologic features and their territorial seas. The maritime disputes refer to the waters beyond the territorial seas and what state has sovereign rights to exploit the resources of these waters, their seabed and subsoil. The territorial dispute is governed by customary international law, while the maritime dispute is governed primarily by UNCLOS. There is no international tribunal that has compulsory jurisdiction over the territorial disputes in the South China Sea. The parties must submit the territorial dispute to voluntary arbitration before an international tribunal can acquire jurisdiction over the territorial dispute. However, the maritime dispute is governed primarily by UNCLOS, and all the disputant states in the South China Sea are parties to UNCLOS. In particular, both China and the Philippines have ratified UNCLOS and have given their consent upon ratifying UNCLOS to be bound by the compulsory dispute settlement mechanism of UNCLOS. The maritime dispute in the West Philippine Sea between Philippines and China has been settled with finality by the July 12, 2016 Arbitral Award, which is binding on both China and the Philippines. On the territorial dispute, China refuses to submit the territorial dispute to arbitration, and the ASEAN states are also not keen on submitting the territorial dispute to arbitration. However, ASEAN, which is aiming to achieve an economic union, must institute a compulsory dispute settlement mechanism for its territorial disputes, and this should start with the Spratlys territorial dispute. Failing this, the territorial disputes in the Spratlys and Scarborough Shoal will be resolved but for all claimant states, including China, by the forces of nature. Sea level rise in the next century will submerge the entire Spratlys and Scarborough Shoal, and once submerged by the action of nature, the submerged areas within 200 nautical miles from the Philippine archipelagic baselines will form part of the EEZ of the Philippines. So time is on the side of the Philippines. On the code of conduct, this code of conduct is probably among the longest code ever negotiated by states. About 20 years have now passed since the 2002 Declaration of Conduct was signed between China and ASEAN, which called for the negotiation of the Code of Conduct. There is still no Code of Conduct at this time. China refuses to even mention the arbitral award in the Code of Conduct. The Philippines insists that the award be made part of the Code of Conduct. Vietnam insists that the parasols be included in the Code of Conduct. China refuses to include both the award and the parasols in the Code of Conduct. Frankly, I do not see how a Code of Conduct can be agreed upon in the foreseeable future. Let's go to the challenges to the enforcement of the arbitral award. The challenges to the enforcement of the award all come from two sources. First, from China, which is expected since China refuses to accept the award. And second, from a totally unexpected source, from President Duterte of the Philippines. Why? First, after the issuance of the award on July 12, 2016, President Duterte announced that he was setting aside the award in order to secure some 22 to 24 billion US dollars in loans and investments from China. Less than 5% of these loans and investments have materialized, and nothing more is expected since President Duterte's term of office will expire in June next year. Second, in September of 2016, President Duterte announced publicly that the Philippine Navy shall patrol only the territorial sea of the Philippines facing the West Philippine Sea, and that the Philippine Navy will not patrol Philippine EEZ in the West Philippine Sea. Third, President Duterte suddenly announced in July 2019 that he had entered into a verbal fishing agreement with President Xi of China, allowing Chinese fishermen to fish in the EEZ of the Philippines in the West Philippine Sea. This is in derogation of the exclusive sovereign right of Filipinos to fish in Philippine EEZ in the West Philippine Sea. Fourth, President Duterte announced in his July 2019 State of the Nation address that he is inutile, yes, inutile, when it comes to defending the West Philippine Sea. Fifth, President Duterte announced in November 2018 during the ASEAN-India Summit in Singapore, and again in his July 2019 State of the Nation address, and repeating it again in his July 2020 State of the Nation address, and most recently, again last April 19, 2021, President Duterte said that, and I quote, "China is in possession of the West Philippine Sea," end of quote. This is the mantra of President Duterte. This is, of course, factually, grossly incorrect, because China actually is in possession of only 8 geologic features in the Spratlys plus Scarborough Shoal. And the territorial seas of these 8 geologic features, where territorial seas are applicable, constitute less than 7% of the total maritime area in the West Philippine Sea. Now, all these challenges to the enforcement of the award coming from President Duterte himself are, of course, grave and serious self-inflicted blows on the national interest of the Philippines. So how do we enforce the award given these circumstances? The arbitral award will have to be enforced under a new administration after President Duterte leaves office in June of 2022. How will the award be enforced after Duterte leaves office? The other ASEAN coastal states, 4 of them, Vietnam, Malaysia, Indonesia, and Brunei, actually agree with the award. Among the disputant states, China is the sole obstacle to the enforcement of the award. Outside naval powers agree with the award. Russia does not oppose the award per se. The position of Russia is that outside powers should not intervene in the South China Sea dispute. Now, can the award be enforced without the participation of China, since China will obviously not enforce the award against itself? We'll have to examine what the award is all about. There are 3 main aspects of the award. First, the 9-dash line has no legal effect and cannot serve as basis to claim waters and resources beyond what UNCLOS allows. About 25% of the South China Sea are high seas. And these high seas are surrounded by the EEZ of coastal states. Second, the Philippines has an EEZ in the West Philippine Sea, unimpaired by China's 9-dash line. Third, none of the islands in the Spratlys and Scarborough Shoal generate an EEZ, only territorial seas. What countries agree with these 3 aspects of the award? All ASEAN coastal states, the 5 involved in the dispute, agree with these 3 aspects of the award. The Philippines, Vietnam, Malaysia, Brunei, Indonesia agree, of course, with this award. All outside naval powers agree with these 3 aspects of the award. The US, UK, France, Japan, Australia, Canada, India, the rest of EU, and Russia. Russia only opposes the intervention of outside powers. What countries oppose these 3 aspects of the award? Of course, China. Now, the small states outside of the South China Sea that sided with China's position during the arbitration are now silent. Besides, these small states do not matter in the enforcement of the award since they have no presence in the South China Sea. In effect, China is the only state that constitutes an obstacle to the enforcement of the award. Now, what initiatives can be taken under these circumstances to enforce the award without China's participation? There are several initiatives. The first initiative, the ASEAN 5 coastal states can enter into a convention on the South China Sea, adopting the 3 aspects of the award, and in effect enforcing the award by state practice. The convention will state coastal states in the South China Sea can claim only a maximum of 350 nautical miles maritime zone in accordance with UNCLOS, broken down into 12 nautical mile territorial sea, 200 nautical mile EEZ, and 150 nautical miles extended continental shelf from the edge of the EEZ. Thus, there are high seas in the middle of the South China Sea, beyond the EEZ waters of coastal states. And in the high seas, there is freedom of navigation and overflight in accordance with UNCLOS. Second, all the heightened geologic features in the Spratlys generate only 12 nautical mile territorial seas, and not a single geologic feature generates an EEZ. Beyond the territorial seas of the islands in the Spratlys are the EEZs of adjacent coastal states if within 200 nautical miles from their respective baselines. In these EEZs, there is freedom of navigation and overflight in accordance with UNCLOS. Third, all historic rights, including traditional fishing rights in the EEZ, were extinguished upon effectivity of UNCLOS as stated in the award. Traditional fishing in the EEZ can be recognized only with approval of the adjacent coastal states in accordance with UNCLOS. In other words, the convention of these 5 ASEAN coastal states will mirror the 3 major aspects of the award. This convention will be open to accession by all coastal states of the world. And for certain, the US and its allies will join the convention. So by state practice of all coastal states that have an interest in the South China Sea, the major aspects of the award will be enforced. Only China will not be complying. A second initiative is that the ASEAN 5 can conduct joint patrols in each other's EEZ to demonstrate to the world that each of them has their own EEZ free from any encroachment by China's 9-dash line. This enforces the award by state practice. A third initiative, the Philippines can join the freedom of navigation operations of the US, UK, France, Japan, Australia, and Canada in the West Philippine Sea. These FONOPs are the most robust enforcement of the award. Every time the US and its allies conduct these FONOPs, freedom of navigation overflight operations, which includes naval drills, they demonstrate to China that there is an EEZ in the West Philippine Sea where they can conduct naval drills in accordance with international law and UNCLOS. Now, in the West Philippine Sea, there is only one adjacent coastal state that is entitled to an EEZ, and that is the Philippines. These FONOPs, which now take place once every 45 days, forcefully debunk China's claim that there is no Philippine EEZ within China's 9-dash line in the West Philippine Sea. A fourth initiative, the Philippines can file its extended continental shelf claim of the coast of Luzon facing the South China Sea before the UN Commission on the Limits of the Continental Shelf. The extended continental shelf is 150 nautical miles seaward measured from the edge of the EEZ of the Philippines. And this assumes the existence of a Philippine EEZ of the coast of Luzon facing the South China Sea. The only country that can possibly oppose the Philippine extended continental shelf claim in this area is China. But China can no longer raise the 9-dash line because an UNCLOS tribunal had already declared it invalid to claim any maritime area, and the UN's Commission on the Limits of the Continental Shelf will likely respect the award of an UNCLOS tribunal. If China opposes the Philippines' extended continental shelf claim, China must invoke that it overlaps with China's own extended continental shelf claim, forcing China to argue on the basis of UNCLOS and not on the basis of historical rights. In effect, China will have to follow UNCLOS. If China raises its overlapping extended continental shelf claim, then the Philippines can bring the matter to compulsory conciliation under the compulsory dispute settlement mechanism of UNCLOS. Now, this will put China in a dilemma. If China does not oppose the Philippine extended continental shelf claim, then the UN Commission on the Limits of the Continental Shelf will affirm the Philippines extended continental shelf claim, just like the way that the Philippine extended continental shelf claim in the Ben-Am Rise was affirmed because there was no opposition. A fifth initiative, the Philippines can encourage Indonesia, Malaysia, and Vietnam to question, under the compulsory dispute settlement mechanism of UNCLOS, China's claim to traditional fishing rights in their EEZs. The present award is binding only between China and the Philippines, and the other ASEAN coastal states cannot invoke legally the award. They can file their own case so that they can have their own award by questioning China's 9-dash line again, because under the 9-dash line of China, China is claiming traditional fishing rights in their EEZ. And of course, a tribunal would also come out with the same ruling as the award of July 12, 2016. This will fortify and reinforce the award. A sixth initiative, the Philippines can also sponsor a resolution in the UN General Assembly demanding that China comply with the award. Nicaragua did this in 1997 when the US refused to recognize the decision of the International Court of Justice ordering the US to pay damages to Nicaragua for mining the harbors of Nicaragua and supplying arms to the Contra rebels. In 1980, the UN General Assembly overwhelmingly voted to require the US to comply with the ICJ ruling. In fact, only Israel voted with the US. Mauritius did the same thing to the UK recently, with the UN General Assembly voting in 2019 by a margin of 116 to 6 to approve the opinion of the International Court of Justice that the UK should return the Chagos Archipelago to Mauritius within 6 months. The great majority of the members of the UN will, of course, be sympathetic to the Philippines, since the Philippines has an UNCLOS arbitral award in its favor. Besides, the great majority of members of UNCLOS, who compose the majority of the members of the United Nations, will not want UNCLOS to collapse. Even if China, through its checkbook diplomacy, has bought off some small coastal states, the G7 and other naval powers combined have given much more aid to other developing countries than China. A resolution of the UN General Assembly calling China to comply with the award will send a strong moral message to China that the world will not legitimize China's illegal seizure of the South China Sea. A 10th initiative, and the last I will propose, the Filipino people must correct the false mantra of President Duterte that China is in possession of the West Philippine Sea. President Duterte has always been saying this: China is in possession of the West Philippine Sea. This is false. Despite President Duterte's order not to patrol beyond the territorial sea, the Philippine Navy and Coast Guard have continued to patrol our EEZ in the West Philippine Sea. The other day, the National Task Force of the West Philippine Sea of the Philippine government announced that the Philippine Navy and the Coast Guard, that their vessels, despite their meager naval assets, will continue to patrol our island territories and our EEZ in the West Philippine Sea to show to China and the world that China is not in possession of the West Philippine Sea. President Duterte cannot stop the Philippine Navy and Coast Guard from doing their duty under the Constitution. I salute our Navy and Coast Guard for defending our sovereignty and sovereign rights in the West Philippine Sea against all odds. Organizations like the Philippine Bar Association, the Integrated Bar of the Philippines, and other civic and social organizations in the Philippines should do no less. Shout out to President Duterte that China is not in possession of the West Philippine Sea. Shout out loud so that President Duterte will wake up from his sleep under his kulambo and admit to the nation the truth. China is not in possession of the West Philippine Sea. I end my short remarks here. Thank you and a pleasant day to everyone.
Thank you very much, Justice Carpio. As you characterize, we are not only dealing with external threats or the Goliath, but also what you called self-inflicted blows that fortunately can only be resolved by a new administration. We do hope that, as you mentioned, nature and time is in our favor for certain resolutions, but for everything else, we are not helpless. We still have options and can act through the International Tribunal and seek the cooperation of our ASEAN neighbors. It is also important, as he emphasized, to change the narrative that China is in possession of the West Philippine Sea. And Justice Carpio, you've been a very solid voice on this, and the call of Justice Carpio is for us to speak loud and clear on this matter as well. So, presenting his point of view on this important topic as well, we move on now to our second speaker, who has kindly agreed to join us all the way from London, despite the fact that it's an ungodly hour there at this point. Let us all welcome Dr. Brendan Plant. Dr. Brendan Plant is a Hopkins Parry Fellow and Director of Studies in Law at Downing College, University of Cambridge, and a Fellow at the Lauterbach Center for International Law, also at the University of Cambridge. Dr. Plant holds honors degrees in economics and law from the University of Sydney and a master's degree in human rights from the London School of Economics and Political Science, where he was a Chevening Scholar. His doctoral thesis, undertaken at Cambridge, focused on international, territorial, and boundary disputes, and the monograph based on this research, The Principle of Effectiveness and the Adjudication of Territorial Disputes, was published by the Oxford University Press in 2017. Dr. Plant's current research and teaching interests include international dispute settlement, territorial sovereignty and international boundaries, human rights, and the history and theory of international law. Let's all welcome Dr. Plant.
Well, thank you. Thank you very much indeed for those warm words of welcome. And thank you to the Philippine Bar Association for the invitation to contribute to this timely discussion and to speak alongside such eminent and esteemed individuals, including Justice Carpio, Professor Koo. Now, as it's just been mentioned, it's coming up on 3 a.m. in the morning here in Cambridge. And while I've said many times in the past that the problem of securing and maintaining the rule of law in international affairs is a problem that keeps me awake at night, I didn't exactly have this in mind, I'll admit. But even though it is the middle of the night here in Cambridge, I'm delighted to be with you to discuss one of the enduring and most vexing questions confronting the international legal system, that is the enforcement of international law. Now, make no mistake, the matter of enforcement of international law has long been a sore point in the theory and practice of international law. It's one of the reasons why our colleagues versed in domestic systems often look disparagingly at international law as immature, as underdeveloped, deficient when compared to a domestic system, whereas it's better viewed as simply different on account of its decentralized, horizontal character. Now, whilst the matter of enforcement has agitated us for centuries, today we're discussing a specific manifestation of this general problem: how to achieve compliance with a binding ruling handed down by a properly constituted international tribunal, which is adverse to the interests of one of the world's major powers. This could well be, as Jean mentioned earlier, a Gordian knot, which proves most difficult to loosen. Now, to start off, with this, I'd like to draw attention to the remarks of Shabtai Rosen. He's a leading Israeli scholar of international dispute settlement. And he has observed that in international law, there's a separation between the adjudication and post-adjudication phase of a dispute. Once a court's final decision is made, the parties to that decision are faced with the problem of its implementation. And it's only upon implementation of the tribunal's ruling that brings the dispute to its end. Now, Rosen reminds us that the adjudication and post-adjudication phases of this overall process each have a very different character. In particular, whereas judicial or arbitral settlement is provided wholly on the basis of the applicable law, as with any legal decision-making, the post-adjudication phase is primarily political in nature, and strategies and techniques must be devised and pursued to motivate a state to comply with an order made against it. For so long as we lack a single unitary pyramidal enforcement structure, perhaps with some sort of monopoly of force, we must grapple with the intricacies and the peculiarities of this system, that the realization of a legal award is invariably politicized. Now, while politics plays a major and probably even predominant role in the post-adjudication phase of a dispute, as so many of Justice Carpio's quite striking and motivating initiatives indicate, it would be a mistake for us to neglect the importance of the law in structuring this process and structuring the post-adjudication phase of a dispute. The process may be politicized, but it is not wholly political. The law shapes and limits the whole problem of compliance. It allows us to identify which elements are authoritative and binding. And by us, I mean not just the parties bound by the ruling. Neighbors, allies, friends, and enemies are able to determine these elements as well. We're able to determine which elements are optional or optimal for the conduct of peaceful and stable international relations. We're also able to determine through the law those alternative legal avenues which might exist in the case of disavowal or disapproval of a ruling by one of the parties, which of course the scenario we confront today in the West Philippine Sea. Now, I intend this morning to leave it to others to discuss the political dimension of the present moment in the aftermath of the 2016 award, or the post-adjudication phase of the 2016 award. I purport to say nothing definite about the fragmentary information that I've gleaned about the events which are playing out at present in the South China Sea and the West Philippine Sea, particularly in respect of the Whitsun Reef. Instead, this morning, I want to focus on the legal technicalities and formalities of the current situation, with a view to developing a fuller understanding of how international law might be used to induce behaviour which is compliant with the declarations made in the 2016 award. So my aim is to discuss with necessary brevity and some speed, unfortunately, three key things. Firstly, what exactly is the content and character of the 2016 award? If we're worried about enforcement, we should be clear about what is enforceable. What is enforceable in that award? Secondly, what is the specific effect of that award? What is its legal status and implications? And finally then, what options are formally available in the event that China acts in a way which is inconsistent with the authoritative declarations delivered by the tribunal in 2016? So, very briefly, let's remind ourselves what was decided in the 2016 arbitration. It is less than many people have come to think. Justice Carpio reminds us that it says nothing at all, of course, about land territory. It says nothing at all about rights of territorial sovereignty over islands or other maritime features in the region. The dispute, of course, concerned 15 different submissions presented by the Philippines. These were grouped into 4 basic disputes. First, a dispute about the source of maritime rights and entitlements in the South China Sea. One might say a dispute about the applicable law, historic rights or UNCLOS. The second set of disputes concerned maritime zones generated under the convention by the Scarborough Shoal and certain other features, as Justice Carpio has told us. The third set of disputes concern the lawfulness of China's actions in the South China Sea, interfering with the exercise of Philippines' rights under UNCLOS, including fishing, oil exploration, navigation, construction of installations, failing to protect and preserve the marine environment by tolerating and supporting damaging Chinese fishing practices, and inflicting severe environmental harm by land reclamation works and construction of artificial islands. The fourth category of disputes raised in the Philippines' 15 submissions relates to the conduct of China during the dispute itself. The Philippines claimed that China aggravated and extended the dispute by restricting access to Philippine Marines stationed at the Second Thomas Shoal and proceeding with the construction and reclamation works at 7 reefs in the Spratlys. Again, this is not about islands or sovereignty thereupon, nor is it about maritime boundary delimitation, rather about emphasizing the bases for that process without pursuing that process itself. Now, of course, we know China rejected recourse to arbitration through public statements and diplomatic notes. It neither accepted nor participated in the proceedings, and of course it has not accepted the ruling handed down. Now, what is enforceable about the award? The enforceable element is found solely in the dispositif. The formally binding of the award is Chapter 10, the first part of which relates to jurisdiction, having been challenged by China, but reaffirmed by the tribunal. But Part B relates to the merits. And the dispositif is declaratory in nature. The tribunal declared a series of clarifications of the parties' respective rights and obligations, clarifications of the applicable law in respect of the various elements of the dispute, the basis for claiming maritime rights, the various maritime entitlements generated by various features, for example. It also declared the wrongs committed by or attributable to China. There were numerous findings of breach by or attributable to the Chinese state. For example, China was aware of, tolerated or failed to exercise due diligence to prevent fishing by Chinese vessels, Chinese flagged but non-state vessels. In that respect, China breached its obligations by failing to exhibit due regard for the Philippines' sovereign rights. Official state vessels of China unlawfully prevented Filipino fishermen from engaging in traditional fishing at Scarborough Shoal, as Justice Carpio reminded us. And finally, that China was aware of, tolerated, protected, and failed to prevent environmentally destructive activities by other non-state actors, again, fishermen from Chinese flagged vessels. So China was declared to be in breach of a number of its obligations under UNCLOS. But again, the award is declaratory. There are no remedies specified in the award. There are no statements as to specific steps that should be taken or acts which must be executed by, in this particular case, the responsible state, China. And it's worth noting that a declaration is fundamentally different from an executory judgment because of that lack of any specific requirement incumbent upon the parties to do anything after the judgment has been handed down. It's not like a judicial order for compensation or restitution or even a formal apology. This judgment merely specified the legal relationship of the parties, clarifying the exact basis of their respective rights and responsibilities in circumstances where there was confusion because both states presented rival views. Now, a declaratory judgment like this settles the legal situation as between the parties who are bound by it, but it only binds their future conduct, prohibiting future breaches of the same type. This is a principle enunciated in a very important early international case, the Khotsov factory case, where the Permanent Court of International Justice, the ICJ's predecessor, observed that the purpose of a declaratory judgment is to ensure recognition of a situation at law once and for all, and with binding forces between the parties, so that the legal position thus established cannot again be called in question so far as the legal effects ensuing therefrom are concerned. This declaratory effect doesn't require anything specific in a remedial sense, but it does make clear in a binding sense to the parties, to the regional and global community, of the apt basis for resolving matters like this one. Now, we know that both parties were bound by this ruling. In terms of status and effect, that is clear. This ruling is binding by virtue of Article 296 of UNCLOS, together with Article 11 of Annex 7 of UNCLOS. And of course, both the Philippines and China, we know, are parties to that convention. But it's also binding as a matter of customary international law. There's a general principle of international law according to which when states agree to submit their dispute to an international tribunal, they assume the obligation to comply with the decision of that tribunal. Of course, China says it didn't agree to submit the dispute to an international tribunal. But the usual reckoning with such an argument, and the tribunal's view in the South China Sea Award, is that by becoming a party to the UNCLOS Convention, the Chinese, as a state party, prospectively submitted their consent to the arbitral and dispute settlement framework elaborated in Chapter 15. Now, we know through the second half of the declarations made in the awards dispositive that China was responsible for internationally wrongful acts. The PCA declared that China breached its obligations under Articles 279, 296 and 300 of UNCLOS, as well as general international law, not least in respect of the conduct which aggravated the situation on the water during the circumstances of that case. And I notice a comment there, China opted out of all of the compulsory procedures in UNCLOS. Let me pick up on that straight away. There are certain exceptions to the bindingness as compulsory of dispute settlement procedures in UNCLOS. Some which are limited are obligatory for all states and others are optional, but the tribunal made clear that the South China Sea award fell without the scope of the exceptions to the compulsory provisions of Chapter 15. So I can answer that comment right away. So if China is responsible for an internationally wrongful act, we must ask ourselves, what are the consequences of international responsibility? They are cessation, non-repetition, and reparations. These consequences arise automatically by operation of law. So while the tribunal didn't specify remedial orders, by declaring that China was responsible for breaches of international law, these consequences accrue. But the problem, of course, is that on a practical level, particularly when you have a state unwilling to act in accordance with the commitments that it has made in an instrument like UNCLOS, an injured or otherwise interested state must respond. It must take action if it intends to invoke that responsibility and seek redress. And what we're going to talk about a little later on is what more could the Philippines do to make real, to realize, give practical effect to the consequences of the international responsibility which China accrued through its actions prior to 2016. Now, once the court's decision is made, we know it's up to the parties to address the problem of implementation. And it is implementation which brings the dispute to its end. And we should also remember that the state under the obligation to comply with a binding award, in this case, China, is entitled in the first instance to determine how it will discharge its judgment obligation. It falls to China first and foremost to make an assessment of the steps it will take to comply with its judgment. But of course, we know here that China has consistently indicated through various public and diplomatic means that it did not consider itself to be bound by the tribunal, since it considered that the tribunal lacked jurisdiction to decide the matter. Of course, the tribunal, which is vested with the inherent power to determine finally its own jurisdiction, considered China's objections, even though they were not properly or regularly submitted to the tribunal. It considered them and rejected them, concluding that the tribunal's jurisdiction to decide the matter was well-founded. So in these circumstances, the problem of ensuring compliance with the decision is, as I said at the outset, essentially a political problem, because the conduct of a state which does not follow the pattern of conduct prescribed in the binding statements of that state's legal obligations, here the award and the UNCLOS Convention, is the very source of the problem itself. That problem is accentuated here by virtue of the heft which China enjoys in the conduct of international relations today. Now, I offer no conclusions as to whether China's actions, as reported in the press, are not compliant with the declarations made by the tribunal in 2016. There will always be difficulties associated with attributing to a state the actions of non-state actors like private fishermen, like the pilots of Chinese flagged non-state vessels, for example. And also there's a problem of location. Where exactly the acts are taking place? Do they fall within the scope of the declarations which were made by the tribunal in 2016 is a live question. But if we were to assume that China has not complied with the 2016 award, that in itself is an internationally wrongful act. Not complying with a binding ruling is an internationally wrongful act, which may form the basis of a new dispute. The non-compliance is internationally wrongful, a breach of obligations under UNCLOS and customary international law, which gives the Philippines as injured state the same rights it would have had when faced with any other internationally wrongful act. In order to induce the recalcitrant state to comply with the decision, the Philippines, the state whose interests are adversely affected by the non-compliance, has the right to take such measures as it deems appropriate within the general framework of international law. So, what are those options? What are the legal avenues available to the Philippines as a state whose interests are adversely affected by China's non-compliance with the 2016 award to respond in a way that might motivate China to act in a way which is compatible with the 2016 ruling? And there is a wide range of actions colored politically in different ways, from convincing, coaxing, cajoling, compelling an adverse party to adopt conduct which is favorable to the aggrieved party, going from persuasion and encouragement, carrots, you might say, to sticks like compulsion and cajoling in regional settings. All of these options are on the table. What are these options? It seems to me that in looking to affect and influence the behavior of the Chinese, there are a number of options formally available to the Philippines, and these may be grouped into three categories. First, judicial settlement, again. Second, compliance mechanisms pursued within the framework of international organizations, and finally, self-help measures. And I don't wish to predict the success of any of these options, but I must confess that I think the prospects are not especially bright. But let's go through them and understand why. First, judicial settlement again. There are a range of different possible forms of action available to the Philippines at this point in time. The first would be to pursue new action, again, most likely through UNCLOS, because we know that there is a present jurisdictional basis available to seek a specific material remedial order in respect of the original dispute. The original dispute was declaratory. The Philippines could initiate a new dispute in order to obtain a specific binding remedial order. Of course, we would face the same question as to whether or not it is likely that China could be convinced, coaxed, cajoled, or compelled to comply. A second possible form of action is to pursue a new dispute in respect of the non-compliance with the original award. So this would be specifically about China's actions in the post-adjudication phase which do not comply with the declarations made in binding form by the 2016 award. That is an entirely new matter. It's worth noting, if we're thinking about jurisdiction under Chapter 15, that it's been considered by various commentators that a dispute concerning the execution of award rendered under Chapter 14 concerning the interpretation and application of UNCLOS would itself fall within the scope of a dispute concerning interpretation of and application of UNCLOS, so as to be likely compulsory. Now, the third cause of action is to pursue a new dispute in respect of related subject matter, and in particular, sovereignty over islands and or a binding maritime delimitation, where the parties' claims might, after the clarification of the applicable law offered by the 2016 tribunal, overlap. Justice Carpio has mentioned a little about both of those possibilities. Now, with these causes of actions, we're back to square one, in a sense. And the idea might be that through an accumulation of rightfulness, of victory in court, you might think, that the Philippines sends a message to its neighbors and to China about its insistence on observance of a rules-based framework in this important part of the world. Someone's noted the Hague Tribunal seems incapable of enforcing its ruling. Yes, that is correct. There is no basis whatever for international courts and tribunals to enforce their own rulings. As I've said, it falls then to the parties. There has been, as an aside, quite a little bit of research that's gone into querying why it is that states ever comply with rulings made against them by international courts and tribunals, given that no international court or tribunal has the formal or physical capacity to enforce its ruling. Because it is surprising to note that the compliance rate with judgments by institutions like the ICJ is surprisingly high, and in fact a lot higher than a lot of domestic courts in municipal systems around the world. As Louis Henkin, a famous American academic in the post-war period, said, international law is complied with most of the time by most states in most matters. We might be confronting today one of those situations where that generalization doesn't fit. But if we're back at square one, of course, we know that all of the usual elements of the legal framework apply, i.e. the states to the dispute are obliged under the UN Charter, to pursue peaceful means to settle dispute. Negotiation, inquiry, mediation, conciliation, arbitration, judicial settlement, resort to regional agencies, particularly pertinent here, or other peaceful means of their own choice. The choice is given to states because enforcement of international law fundamentally and at all times rests on state consent. Now, I'll just say a few words quickly about venues. Of course, it would be possible, as I've said, for the Philippines to return to ITLOS and perhaps to seek provisional measures, which would be an order issued swiftly to prescribe certain action in order to preserve the respective rights of the parties. Those measures are binding under UNCLOS. But we're already familiar with the situation under Chapter 15 of UNCLOS. So what about the ICJ, the International Court of Justice? This could be a dispute concerning any aspect of the legal components of the Philippines' disagreement with China. Now, there are some advantages to ICJ litigation. Of course, it carries a stronger profile and more prestige, and it also enjoys a much stronger basis for enforcement insofar as the fact that under Article 94 of the UN Charter, each member of the UN undertakes to comply with the decision of the ICJ in any case to which it is a party. Furthermore, under paragraph 2 of Article 94, it is possible for a party, a winning party, so to say, in an ICJ dispute, if that party deems it necessary, to ask the Security Council to use its very considerable powers to enforce ICJ judgments. This is a facility which is extremely potent and has almost never been used. And I'm sorry to say that, of course, in the situation we are discussing, it is a facility which is unlikely to be effective, given, of course, the likelihood that China would exercise its veto power to prevent the Security Council using its powers under Article 94, paragraph 2, to insist forcibly upon compliance with an ICJ ruling. Furthermore, it's worth noting there's no separate discrete basis for jurisdiction between the Philippines and China, and given past practice, it's highly unlikely that China would agree. So let me finish very quickly with a rundown of institutional mechanisms and to talk a little bit more about the UN. Because just as Carpio mentioned the Nicaraguan example in was it 1997, I think he said, where a General Assembly resolution was sought in order to insist upon American compliance with the famous Nicaragua judgment. Now, in the context of the UN, of course, sanctions may be coordinated among member states, and these sanctions are mainly used to maintain peace and aren't typically addressed to the issue of non-compliance with pre-existing obligations so as to restore legality. And yet, that is a possibility which the institutional framework of the United Nations provides. Under Article 14, the General Assembly may recommend measures for the peaceful adjustment of any situation, regardless of origin, which it deems likely to impair the general welfare or friendly relations among nations, including situations resulting from a violation of the Charter. The General Assembly is only prevented from making such resolution if the Security Council is at that time exercising the functions assigned to it. This has been understood to mean, particularly from 1950 onwards in the General Assembly Resolution 377, Uniting for Peace, that if the Security Council fails to exercise its primary responsibility for the maintenance of international peace and security in any case where there appears to be a threat to the peace, breach of the peace, or even aggression, that the General Assembly shall consider the matter immediately with a view to making appropriate recommendations for members to then take collective measures. The Resolution 377 specifically notes that that is a course of action that may be taken if the Security Council doesn't function because of a lack of a unanimity among its permanent members, i.e., if one state exercises its veto power, Article 14, as interpreted by the General Assembly in Resolution 377, provides an institutional course available to the Philippines to bring this matter to the attention of the General Assembly, and with the assistance of friends, allies, and other states committed to the rule of law and international affairs, to make a recommendation for coordinated collective measures to be adopted so as to motivate China to change its course of conduct. Our final option are self-help measures available to the Philippines, and these take two forms: retorsion and countermeasures. In short, retorsion are unfriendly acts which are unilateral self-help measures which don't break any laws, which don't interfere with the target state's rights under international law, but are unfriendly gestures intended to inspire the target state to reconsider and recalibrate its course of action. These often involve interruptions to normal diplomatic relations, embargoes, withdrawal of voluntary assistance, and so on. Countermeasures are different. They are regulated by the Articles on State Responsibility. And countermeasures are a form of self-help where a state, like the Philippines, which is injured by internationally wrongful conduct by another state, is entitled to do something which would otherwise be unlawful, but for the fact that it is a temporary and proportional response to the prior wrongdoing by another state, and a response which intends to prompt that state to correct its conduct. Countermeasures remain a self-help facility that the Philippines could apply in order to convince the Chinese state that it should act in compliance with the 2016 award that doesn't rely upon anybody else, institutional or otherwise. I've spoken too long, so I'll leave this brief sketch of the formal opportunities available to the Philippines in current circumstances there, and look forward to further discussion later on. Thank you.
Thank you so much, Dr. Plant. I know it's past 3 a.m. there, but there's no sign of fatigue in your voice. Truly shows your passion and expertise on the subject. So you emphasize that while ensuring compliance is predominantly political, right, you also mentioned that arbitral decision is binding to both parties under UNCLOS and under customary international law, and that non-compliance with a binding award is an international wrongful act for which an injured state has the right to take measures, right? There are legal avenues, as you mentioned, from the carrot to the stick. So there are peaceful options left for us to address the issue, whether it's judicial settlement, compliance mechanisms with other international organizations, and the importance of sending a message to China for a rule-based framework. But also very interesting, and I hope we can expound on this later during the panel, on the self-help measures when we don't need to rely on everyone else, but on our own actions as a country. So thank you so much, Dr. Plant. We go now to another part of the world. We will be welcoming our third speaker, who is joining us from New York. Professor Julian Koo is the Senior Associate Dean for Academic Affairs, Faculty Director of International Programs, and a Maurice A. Dean Distinguished Professor of Constitutional Law at Hofstra Law School. He holds a bachelor's degree from Yale University and a Juris Doctor from Yale Law School. His research interests includes relationship of international law to constitutional law, and also a wide range of topics, including international dispute resolution. He has been a visiting professor at the College of William and Mary Marshall Wythe School of Law in Williamsburg, Virginia, a Fulbright Distinguished Lecturer in Law at East China University of Political Science and Law in Shanghai, China, and a Taiwan Fellow at National Taiwan University in Taipei, Taiwan. Ladies and gentlemen, let's all welcome Professor Julian Koo.
Okay, thank you so much. And I really want to thank everyone for inviting me to join this conversation, Bar Association, and also the International Committee of the New York State Bar Association for putting together this panel today. So I recognize, especially after those two great presentations, that everyone here in this audience, unlike most of our audiences back here in the United States, are very familiar with the South China Sea Arbitration Award. So I want to try to focus, and also there's some of the things I've been talking that that have already been covered by my fellow panelists. So I don't want to dwell too much on repeating what they've already said. So I do want to offer some thoughts that might draw on my expertise, both as Ms. Krasser mentioned, someone who's both interested in international law, but how it interacts with the domestic law of the United States, but also the domestic law of other countries, and including, say, the Philippines. I want to focus how governments and other actors can helpfully sort of push China on this very difficult issue. And as Dr. Plant mentioned, it's really a mix of both politics and law at this stage, and the law can structure the politics. But policy and politics is a big part of shaping a useful reaction here. So let me just say, so I'm going to first talk a little bit about the ways in which governments can act on the international stage. And to some degree, I'm going to review and then comment on some of the suggestions made by Justice Carpio and Dr. Plant. And then I'll want to talk a little bit about ways in which governments can take steps under their domestic laws and domestic policies to support enforcement of the arbitral award. And then finally, I'll conclude by assessing the likelihood that the effectiveness of any of these actions. Now, at the outset, let me just acknowledge that I'm on the record way back in 2013 as initially a critic of the Philippine government decision to bring this arbitral award. And the reason why I was critical was exactly the problem we're running into today, which was that bringing the award, even if it led to a positive legal result as it did, was always going to be very challenging for the Philippines at this stage, enforcement. And it would have required a really detailed plan, not just to win the law, to win your judgment in court, but a really good strategy to implement and push and use that judgment to defend the interests of the Philippines afterwards. And while I think the legal strategy of the government of the Philippines was extremely effective and was very successful beyond, I think, what I think many observers expected, I think that with respect, the strategy for enforcing the award or using the award to benefit the government of the Philippines and the country of the Philippines has been less so. And I think that's part of the problem we're running into today. It was never going to be easy to get a country like China to comply with an arbitral award that was against it. But I think the Philippine strategy was probably one of the less effective ways it could have been done. And I think that's why it's difficult at this stage, so many years later, to have a positive outlook. Although there are definitely things that some will suggest that can be done that might make a difference. Okay, so having said all that, even though I was a critic of the Philippines government in the beginning, just on the grounds I didn't think, I think it was going to be very hard to win any enforcement, I do agree that as a legal matter, and I think I agree with Dr. Plant and Justice Carpio, and I've written that the arbitral award is final, it's legal, it's binding on China and the Philippines, and I think, moreover, the tribunal's conclusions are quite sensible, and they offer a very reasonable legal framework, I think as Justice Carpio suggested, to resolve many of the problems in the South China Sea that, as Justice Carpio mentioned, putting China aside, I think the tribunal's award could serve as the basis for an extremely reasonable settlement of all the other countries that claimants in the South China Sea because of the way the tribunal did this. So that's good. Now the trick is, how do we push China, which I think Justice Carpio correctly identifies as the main obstacle now to reaching some sort of useful settlement of the various territorial and maritime, especially the maritime disputes in the South China Sea. So one way to do this is first to reframe the narrative and to remind not just the Philippines but the world that it really is, given the way the arbitral award is going, it really is China that's the problem with respect to reaching some sort of settlement. And I think that the strategy I think that the Philippines should think about is trying to use the arbitral award to illustrate that without China, we could reach a settlement. We could have peace and joint development and all the things that people want, that the rest of the world would want in the South China Sea. And the arbitral award is a very good way to do that. And I think and so what needs to happen, therefore, I think the strategy would be, if I was working for the government of the Philippines, was to think about ways to raise that point on the international stage. Now, Dr. Plant has already reviewed the various mechanisms, formal legal mechanisms that the Philippines could have pursued. For instance, although I think this is a little difficult, it is theoretically possible for the Philippines to seek a United Nations Security Council resolution and to seek compliance with the award. This is not an opinion of the International Court of Justice, so there's no direct responsibility for the United Nations Security Council, but the United Nations Security Council has a broad mandate, and it could be and so they could be asked to respond to the situation in the South China Sea. And the Philippines made the point that China is acting by China's actions in breach of the award. It is in fact a threat to peace and security. That is something within the Security Council's mandate. Now, as Dr. Plant mentioned, this will be rejected by the Chinese government because it sits on the Security Council and has a veto. But that doesn't mean it's not worth bringing the claim. In the dispute with Nicaragua and the United States, Nicaragua repeatedly brought this demand to the United Nations Security Council, knowing full well that the United States would veto it. Nonetheless, it benefited tremendously politically and on the international stage by framing the point that we're just Nicaragua, we're just trying to get the International Court of Justice to enforce this award. Look who's stopping us, the big bad bully, the United States. Making China own the actions it's taken by making them veto such a request would, I think, be a valuable political move, which I think is part of what needs to be done to continue to pressure China on this. So I think that's something for the Philippines government to consider. Similarly, the Philippines government could consider, and I'm just repeating what Dr. Plant mentioned here, seeking a resolution in the General Assembly. Now, again, following the pattern that Nicaragua sought in 1988. Again, the General Assembly has no authority to order compliance with the award. But if the Philippines was able to win a majority of the General Assembly to make a resolution supporting UNCLOS in the compliance with the South China Sea Arbitral Award, even though it imposes no legal obligation on China, it would still have a tremendous impact on the international stage to have that kind of vote. Now, it would take a lot of work. It would put the Philippines diplomatic corps they'd have to work really hard and pull out all the stops to pull this off. But it has been done by countries much less resourced than the Philippines, and Nicaragua managed to win 2 General Assembly resolutions in the 1980s against the United States, which were nearly unanimous, with many fewer resources than the Philippines has. So what I would say is this is not precisely a legal mechanism. What I've called this in my own writings, diplomatic shamefare. So the strategy here is not to win a binding action, but to go to the international fora and to try to come up with ways to shame China. And international relations literature has shown that this kind of shaming does have an impact. It won't induce immediate compliance, but it does create costs and raises the costs of non-compliance. And in fact, it did have an impact on the United States in the 1980s. Now, the United States is much more vulnerable to this because there are many groups within the United States that were supportive of Nicaragua, and there isn't such a group probably in China. Nonetheless, it's a strategy that should not be ignored. Now, this is difficult. It requires action by the Philippines to lead this. It cannot be led by any other country because, as Dr. Plant mentioned, the Philippines is the injured party here. Doesn't make any sense for any other party to raise this. And so it would be, and the problem we have here, as Justice Carpio mentioned, is that we're 5 years down the road here, right? This is the type of thing that probably should have been done when the award came out, and it's a little bit late now to do so. Of course, there's always a risk that you might not win such a General Assembly resolution. It's entirely possible, as someone mentioned in the comments. But it is, I think, so obviously this would be a task for the diplomats. I do think, though, this would be a useful way to redirect the Philippines Foreign Service away from the bilateral Chinese conversation and toward other parties in the world, the other countries in ASEAN, as Justice Carpio mentioned, but also countries around the world who may have other thoughts on this and may want to support a small country that feels like it's being taken advantage of by a large country. Okay, so that's one suggestion. And again, it's a little different. It follows tracks what Dr. Plant suggested, but to point out that even if there's no legal binding judgment, these actions on the international stage at the General Assembly at the United Nations, at ASEAN, or at the United Nations Security Council could have very beneficial effects in building the international narrative that China is the bad actor here. And that's very valuable, and that China is the obstacle to peace and security in the South China Sea. Okay. Now, there are other mechanisms that perhaps are more, more meaningful in an immediate sense. And here I turn to some of my interests in domestic law. And this falls under the category that Dr. Plant suggested is either retorsion or countermeasures. In other words, self-help actions by the government of the Philippines to sort of take countermeasures to seek compensation or to impose sanction on the government of China for its wrongful acts under the arbitral award. Now, interestingly, on this front, I think what's interesting here is that there is one country that's imposed economic sanctions on Chinese government entities for their actions in reclaiming land in the South China Sea in violation of the arbitral award. It's not the Philippines, it's the United States government, which in August 2020 imposed export controls on the sale of US products to Chinese companies that have been part of constructing artificial islands in the South China Sea. And the United States government cited the arbitral award as part of its analysis for imposing those export controls. Now, it's worth noting that these export controls don't bar all sales to these Chinese companies. They simply require any US companies that are going to sell to these Chinese companies to seek permission from the United States Commerce Department to do so. But the presumption is that you cannot. And it does pose some sort of barrier against doing business with those companies, and does impose some limitations. But primarily, it actually injures US companies who would otherwise be making money by selling products to these Chinese companies. So I think it's worth noting that this was a really interesting step taken by the United States government to impose economic sanctions on China for something it's doing which doesn't actually directly affect the United States. None of its sovereign interests are being affected. And the steps the United States government took injured US companies, as well as Chinese companies, injured the economic interests of US companies. Now, one of the problems under international law for the United States action in this front is that the United States is not the injured party here. The United States is not being injured by China's actions in the South China Sea in a legal sense. It's not the wrongful party that because it's not part of the arbitral award. It's not even party enclosed. And the creation of artificial islands don't directly impact US interests. So arguably, it's actually illegal under international law for the United States to take these sorts of actions against China for things that don't actually affect the United States people, companies, interests, or territory. Nonetheless, the United States government took such measures, which I think shows the seriousness of the commitment of the United States government to pushing back against China in the South China Sea. However, both legally and practically, it would make much more sense if the Philippines would lead such a move to impose economic costs on China's wrongful acts in the South China Sea. The Philippines would be the injured party. The Philippines, as Dr. Plant mentioned, is this country that's been suffering the wrongs, suffering the violations of its territory. The artificial islands affect the Philippines EEZ. Fish that would otherwise be fished, but within the Philippines EEZ are being taken out by Chinese fishermen. That's a loss not to the United States, it's a loss to the Philippines. So it's kind of mysterious that the Philippines has not imposed, although I know there's been some debate, any such sanctions, even though it's the only country that unequivocally has that right to do so, as Dr. Plant mentioned. So I think that this is a step the Philippines could consider. I know that it has been considered. It might be difficult to do for domestic political reasons, but just if you take a step back, it would be a reasonable step of countermeasures and retortion. So for instance, the Philippines government could say that any company such as the Chinese communications construction company, which does do business with the Philippines, is barred from doing business with the Philippines. And that it would be sanctioned in the way that, because it is in violation of Philippines law, presumably by encroaching on Philippine sovereign rights in the South China Sea. Such sanctions could be expanded by the Philippines to Chinese companies that finance the fishing vessels in South China Sea, Chinese companies that supply the fishing vessels in the South China Sea. The way this sort of sanction process could work could be quite broad if it chose to. Now, I know the Philippines does not have a domestic legal mechanism typically for doing such sanctions, but it is something that the Philippines government could consider. Now, you might say, well, it has no impact because the Philippines might be economically small compared to China. Maybe, but there still might be an impact. And second, I think it would be a really interesting way for the Philippines to demonstrate to the other countries, including the United States, that it really does care about the South China Sea rights that the arbitral awards purported to protect. One of the things that's been going on since 2016, which has affected policy, and I think Justice Carpio addressed this point, is that the other countries don't really believe the Philippines is really that worried about this. Why would we go to bat and incur the wrath of China on behalf of a country that doesn't actually really want to incur the wrath of China? If the Philippines doesn't care about its interests and sovereign rights in South China Sea, why should any other country in the world? And so it's got to start with the Philippines for any effective pushback against what are, after all, in theory anyways, violations of the Philippines' sovereign rights over its EEZ and perhaps over its sovereign territory. One interesting mechanism the Philippines government could choose to do, again, if we're just making up ideas, would be opening up Chinese companies to lawsuits in the Philippines courts for any damages or perhaps wrongful acts that they've taken on the in the Philippines EEZ, right? Philippines, in theory, legally has a right to regulate its exclusive economic zone. Why not pass a law creating causes of action against fishing vessels that unlawfully do so? Now, of course, there are lots of legal problems, jurisdiction and such. But again, it's a way for there to be demonstrate seriousness of that this is a legal right the Philippines has. Companies in China are violating these legal rights. We should be able to try to reach out and regulate activity, including through torts, perhaps tort law, of unlawful acts in what the Philippines government considers to be its exclusive economic zone. Such judgments could maybe be difficult to enforce, certainly, but again, would demonstrate the seriousness of the government in a way, in the Philippines nation, in a way that frankly has not been demonstrated to the rest of the world in the past 5 years. All right, so let me just conclude that on one thing. What's the most likely way to succeed here? Look, I'm not optimistic. I wasn't optimistic in 2013. I'm less optimistic in 2021 that a positive result for the Philippines will come out here. But I don't think doesn't mean I don't think it's worth doing. It doesn't mean I don't think China's the bad actor here for the most part in the South China Sea. And I do think there's opportunities here. It's going to take a lot of work. It takes a commitment. It takes a willingness of the Philippines government and the people to incur costs, economic costs mostly, and to really willing to suffer losses, economic and otherwise, in order to defend what the Philippines people and government say are their sovereign rights. As Dr. Plant mentioned, it is the duty of the parties, and in this case, the injured party, the state's parties, to enforce their rights and obligations under international law. There's no third body that can really do this. And so it's really the task for the Philippines, with the help of its allies, but first and foremost, the Philippines, to make the award any kind of reality. So with that, I'll just stop here and let the conversation begin. Thank you.
Thank you so much, Professor Julian Koo. I know you're not optimistic, but good thing the Filipinos are optimistic by nature. So you've presented several options highlighting diplomatic shamefare, right? The UN Security Council, UN General Assembly resolution to raise the cost of non-compliance. And it's also about redirecting, right? The discussion of foreign affairs, not just directly at China, but also to engage the other members in that discussion. Again, the concept of self-help, right, by the government of the Philippines. And you mentioned that even other countries are taking step, but Philippines must really take the lead, right? Retortion, unfriendly measures. I guess the key term there is unfriendly, depending on how our government defines our friends. But the Philippines has the duty to take the lead. It needs to start with the Philippines. And this has actually sparked debate among our participants in the chat group. So with this, we will now proceed with our panel discussion to be moderated by another expert. So we will now meet Dr. J. Batong Bakal. So he is a full professor and executive associate dean at the University of the Philippines College of Law and concurrently director of the Institute of Maritime Affairs and Law of the Sea of the Law Center. His advanced degrees include Master of Marine Management and Doctor in the Science of Law, both from Dalhousie University in Canada. Since 1997, he has done diverse work and is widely published on maritime affairs and maritime boundaries. Dr. Batong Bakal was legal advisor to the Philippine delegation that successfully pursued the Philippines' claim to Benham Rise under UNCLOS. He is also one of UNESCO list of experts on marine scientific research for purposes of special arbitration. Over to you, Jay.
Thank you, Jean, and thank you to our speakers, especially the very interesting discussions of our guests. I think that it's really very enlightening, especially for the legal community, most of whom are the participants in this webinar. There has actually been quite a lot of divisive debates about the award and its implementation since 2016. And you find in the comments elements of that division, no? The pessimism, shall we say, about arbitration, international arbitration, and UN mechanisms. But underlying all of this is basically a lack of appreciation of the differences between how domestic law and international law works. So the various options and available to us, as elucidated by Professor Koo, preceded by the explanation of Dr. Plant on the differences between the pre-adjudication and post-adjudication phases, is really a very good way to frame the problem of enforcement. No, one obstacle we always encounter in the local debates about this is the assumption most people make, even lawyers, that international law works like domestic law and there is a need for a sheriff or a police officer to enforce the judgment. But as seen in this discussion, enforcement really is primarily the duty, first and foremost, of the parties themselves. And since it's the parties themselves, then the winning party, the victor, has in a way, has as much an onus of ensuring compliance and enforcement as the other party. So it's not really a matter of making the other party act contrary to its will, as is usually expected in a domestic court setting or enforcement and execution of a judgment. It's also primarily about the winning party maintaining its position and acting in the international community in a way that continues to sort of seek compliance with the award, in a way that really upholds the ruling in its favor. I guess the analog for the local litigators would be the declaratory relief, diba? That is very similar to what the judgment, the arbitral award actually is. It's a declaratory relief that establishes the ground rules for how the parties should, from now on, relate with each other on this dispute. Now, it's very interesting. The topic that really appears to be very interesting from that really stands out is the idea of self-help measures. The idea that of the Philippines seeking or having recourses on its own. And of course, people will immediately say, well, we're only a small country and China is such a big, powerful country. What can we do? The kinds of objections that are often raised really are about this narrative, based on this narrative of powerlessness, no, on the part of the Philippines, no, and there is also an underlying thread of a dichotomy between the legal and the political. But as pointed out, these are actually combined. These actually are not entirely separate, and they need to be marshaled and harnessed in the post-adjudication phase. The question that I could raise based on these various comments and inputs really is, what do you think will be the impact if, well, as we've seen, the government's policy pronouncements are always taking off from this defeatist attitude, this sense that there's nothing that the Philippines can do, this sense that we should just ignore the award and just negotiate with China on anything else. No? What do you think will be the impact of that kind of policy if it is sustained by the Philippines after this administration? Would that amount to a waiver and abandonment of the award and therefore all the potential benefits from it? Would that be recovered by a change in policy in the next administration? What do you think, sir? Perhaps Dr. Koo and Dr. Plant?
I'm happy to take a first crack at this. Maybe Dr. Plant might disagree with me, but I don't believe there's a waiver issue here. Although that depends on the specific acts of the Philippines government, but I don't think any of the statements would constitute waiver under international law. But I think, but maybe he has a better view on this than I do. I think that the concern I think would have is that, as Dr. Plant so powerfully pointed out, if it's a duty of the state, the Philippines, to enforce the award, then even if Philippines doesn't waive its rights but just does nothing, then that means it's no one else is going to enforce the award, and so it just kind of lies dormant, and it loses the momentum. I think a lot of momentum has been lost the last 5-6 years. But maybe Dr. Plant, if you want to jump in on this one.
On the waiver point, I agree. I don't think that that's really at issue here. There, of course, waiver and abandonment would be relevant in respect of the territorial sovereignty disputes, which have been on the periphery of our discussion today, but which are a very real part of, one of the key ingredients to the heady mix in the South China Sea at the moment. And the Philippines' actions have been anything but a waiver or acquiescence in that respect. But by simply not acting upon a declaratory judgment, as you picked up on, there's no possibility that if things worsen later, that the Philippines would be prevented or stopped or something like that from initiating an action. It would be, each new wrong would form the basis of a new dispute. So you would have a sort of a serial mechanism where, having clarified what is the apt legal basis for the relations between the parties in the award, any new violation of that basis provides the ingredients for a new dispute to be initiated. So I think it would probably be the opposite of a waiver situation. But don't forget that it is always welcomed by the structures and rules of international law for states to decide to do nothing about these situations, to agree that actually it's not worth it. And given that a certain stability or friendliness of relations can be maintained, then not insisting upon the full letter of the law is something that international law is generally pretty comfortable with.
Okay, thank you. We're now going to...
Just while I think of it though, so I was just going to make one remark when you mentioned, Professor, about changing the posture from one of of powerlessness to something that is more assertive. The one thing that I would observe is that I think a lot of the Philippines' neighbours might be entertaining similar thoughts at the moment, that there could well be a tipping point in the region, both Pacific and broader around the Pacific, that could produce effects. And you can see what's happening in India, in Australia, in particular at the moment. There are a lot of different states who are going through similar processes. And if each thinks of their own situation as one of powerlessness, then the combination of them produces a quite different complexion. And that's something that, that the Philippine authorities could well be contemplating.
Okay, let me add to that discussion. I agree that if we do nothing, we do not waive. We can only waive it if we expressly waive it, or if by some conduct we are waiving it, like if there's a unilateral declaration by the president that is waiving it. And I think we almost reached that point. In 2017, the president said, "I am setting aside the award." He really said that. And of course, when you set aside the award, you abandon the award. And the rule is that would be binding on the Philippines if accepted by China. So I called up the people at DFA, Department of Foreign Affairs, to immediately clarify the statement of the president that he was not abandoning the award. He was merely putting it aside to raise it at some future date. He was not setting it aside, because to set aside is a technical term. We use that in law. You set aside the order of a lower court. So we made the clarification. The DFA said we are not abandoning. Where the statements of a head of state or foreign minister can bind if accepted by the other party in a dispute. So we have to be very careful.
Unfortunately, we seem to be encountering some connectivity issues. We will get back to Justice Carpio when he is able to reestablish contact. Okay. But in the meantime, perhaps we can follow up on several queries that they were is that notwithstanding the ruling of the tribunal with respect to China's actions that damaged the marine environment, China did continue certain conduct. And as late as 2019, there were actually caught on video the operations of their giant clam fishers were on video. And so in a way, the actions that were already declared to be wrongful continued. And what was also striking was that the operations of these clam diggers were taking place within the view and essentially under the protection, perhaps, of the China Coast Guard. Okay, these videos were taken on Scarborough Shoal, and actually there were prior reports in 2016, 2017, and 2018 that were sent up to BFAR for that. Perhaps we could. Justice Carpio has returned. Perhaps we could ask him to first finish his remarks that got cut off, and then return to that point that I was trying to make. That what possible venues could there be to seek redress for the continuing transgressions, basically on the point about the damage to the marine environment? No, what kind of potential case, shall we say, or potential legal avenues would be considered by the Philippines to try to at least get some part of the judgment still enforced and complied with. But first, Justice Carpio, sorry, you got cut off at a certain point in your remarks.
Yes, I was saying that we were able to prevent being being subjected to a possible waiver under the unilateral declaration doctrine. So we were able to save that that issue. Now, on your question on what possible actions we can take for the damages, I think we can bring a new action to recover damages that occurred after the ruling came out. Because after the ruling came out, China still continued harvesting giant clams, and China continued to deny our fishermen full rights to fish in the territorial waters of Scarborough Shoal, and China's continued to fish in our EEZ. We can recover damages. There's a question, and I doubt we can recover damages for actions, for acts that China did before the ruling, because we did not ask for damages for what China did, but we can ask for damages for acts that China or Chinese fishermen did after the ruling came out, like preventing our fishermen from fishing in Scarborough Shoal. Thank you.
Thank you, Justice Carp. So perhaps Dr. Plant or Professor Gu could say something about this idea of pursuing, well, further remedies, no, for continuing violations or continuing contravention of the arbitral award. So you mentioned several options, no, but perhaps it would be enlightening to our audience if you could give a little more detail on, say, a particular feasible option.
Okay, I'll take this. I'm sorry to say that I'm not sure how feasible any of the options might be with a pragmatic analysis. We've got the real problem of jurisdiction to grapple with. And as I said, whilst it might be the shame fair that the Professor Koo mentioned, my favorite word of the day so far, shame fair would be much more effective somewhere like the ICJ, where the eyes of the world are trained on the courtroom. There's no prospect of that venue for a dispute about marine environmental damage for so long as China has no optional clause declaration. You know, it would not consent to going to the ICJ in order to hear any of these matters. And instead, I think that the only option that is really available to the Philippines relates to UNCLOS with its integrated system of limited compulsory dispute settlement. And if it would be possible for the specific wrongs alleged, about which I don't know anything specific, to be brought within the scope of the jurisdictional framework of UNCLOS Chapter 15, and the 2016 award suggests that that's possible, then that's really the only viable forum, as I see it, for the Philippines to pursue judicial settlement.
Can I just quickly add that I agree, and I think that it would be the key to this, and would be that if the Philippines wants to go down this road again, the government needs, at least I would advocate the government plan out a post-adjudication strategy, and also accept that the adjudication is uncertain, they might still lose, but that even if they win, they still need a post-adjudication strategy. And I think this, again, what I was saying, and I don't mean to be a carping critic about this, but I think any international legal adjudication the strategy needs to be beyond merely winning your case. And there needs to be, you need to think out, what are you going to do with that case? What message do you want this case to make beyond just the legal judgment? And I think that's hard for lawyers because we're just trained to win the case. But I think for international law, and for especially in this context, a political, diplomatic, unified legal strategy where the law may not even be the most important part of the strategy is important. So maybe we need not just lawyers in the Philippine Bar Association, but the Philippines foreign service officers and all the other sort of folks, political strategists that the Philippines can bring to bear.
Can I just add that I completely agree with everything that Professor Koo has just said, and I, particularly with the blindedness of lawyers, I plead guilty to that all too often. But one thing that is worth thinking about is the community effect of having these clear statements from tribunals, which are still respected by many actors in your neighborhood and beyond. Having clear statements as to what the legal consequences of certain actions ought to be, what their characterization is, can be extremely powerful for the diplomatic actions, for structuring, designing, pursuing the diplomatic actions, which would make one hopes, practical difference.
I just mentioned one other thing I forgot to mention. As I think it was mentioned, the Chagos General Assembly referred the United Kingdom to, I believe, to the International Court of Justice for advisory opinion. General Assembly has that authority, and so, but it had a measurable impact, even though it was just an advisory opinion. So, it's a great example of the legal strategy, which isn't really a win, had a real impact. Now, again, the UK is more vulnerable to this kind of pressure than China is, because the UK has all these people who like to follow the law within the system. But still, I mean, I think it really does have an impact, and something to consider in that way.
I was going to mention the Chagos Islands when you talked about, sorry, Professor, to jump in there. I was going to mention the Chagos Islands because unfortunately, it's a situation where an holistic strategy was pursued, and there was a clear sense of progression from the arbitration, and there've been legal procedures going on in Britain, internationally, in Mauritius for 20 years now, and to have obtained a useful result in arbitration then was the launch pad into pursuing the advisory opinion. But spoiler alert here, I'm sorry to tell you, there are still some people who like to follow the rule of law in England, but not everybody. And the UK has refused to abide by the non-binding advisory opinion which the ICJ has rendered. So we now have maps produced by the United Nations which identify the Chagos Islands differently and relating them to Mauritius, whereas the old British maps still include them as part of the British Indian Ocean territories. But in terms of Britain's own position and its claim to administration over those islands, there hasn't been any change at all. And the lease which is signed between the US and the UK remains in force.
Thank you. Thank you. Actually, that really highlights the idea that when you talk about a post-adjudication strategy, you really have to be prepared for the long haul. Commitment is very important, as well as consistency in advocating your position. And I think that's where we have a problem here with respect to the Philippines versus China arbitration award. As soon as the award was handed down, a different administration decided to take a totally different and diametrically opposed route. And so whatever strategy might have been prepared, simply was dropped in favor of what was at the time called a soft landing, and a setting aside or putting aside in favor of promises of infrastructure development and financing. Now, One thing, one question that was raised in the chat box. Please type in your questions in the chat box, either in the Q&A or the chat, because I'm monitoring both. One question that was raised is if our guests could take a look at the various courses of action that were presented by Justice Carpio. There are about 10 of them. Which do you think would be most viable or most feasible to pursue? No, and whether these options, no, could be part of this broader, longer and long-term strategy.
Let me I did have a couple thoughts, and I want to salute Justice Carpio for his really creative, tireless advocacy on these issues, but also his creativeness, his creativity, which I think is also very helpful here. Just speaking from someone who's outside the situation. I was struck by the one thing, I don't know how feasible it is, but it would have, to me, the most impact would be some sort of agreement between the ASEAN, what he calls the ASEAN 5. And I think this is where I think there's a lot of promise if it's easier said than done, but if the states could agree that the terms of the award would be the basis for the settlement of maritime relations, I think that would have a tremendous impact around the world, and it would further isolate China, and it would give legal force to it. Now, really hard to do. And presumably there's still territorial disputes that are lurking in there that would be that would not be resolved. And also, I know ASEAN is all about consensus, and it is not in favor of a group breaking off. So I know that there are a lot of issues, but I'm not an expert in the region. But if I were looking at the outside, if such an agreement could be arranged, I think that would probably have the most impact. That would again require the Foreign Service Philippines to really go all out. But I think it would be worth it if you could get such an agreement. Quite challenging though.
Thank you. Thank you, Professor Koo. What about Dr. Plan? Do you have any thoughts on the various options that were presented by Justice Carpio? I know that you addressed some of them already, but perhaps the ones you didn't get to earlier.
I suppose one of the things which has come out a few times is the fact that there is as I've said, a community effect. We sometimes say erga omnes effect, an objective effect of obtaining a ruling that declares a situation clearly where previously there was room for confusion, and that other states, allies, friends, and so on may take advantage of those declarations for their own purposes. And I noticed that Justice Carpio talked about that. We could encourage allies to query practices, question the 9-dash line again, and so on. I did think during that section that this has to be leavened against the political calculation, which I'm not suited to make, about the possibility of irritating a major power in the neighborhood, which has already obviously indicated its displeasure with certain of its neighbours grouping together. In particular, it's had a lot to say about Australian, Japanese, Korean and American cooperation and concerns about encirclement. This is, the politics writ large of using legal clarity for a necessarily politicized process where a fine line needs to be cast between brokering friendships, using alliances, producing strength in neighborhood solidarity, but perhaps not going too far with it so as to prompt the biggest power in the neighborhood to dig their heels in and become perhaps even more recalcitrant. So it's always a question that I know State departments and foreign officers are very concerned about. The other issue, I would say, just from a lawyer's perspective, is that questions concerning maritime entitlement in the continental shelf are quite separate. And I think that they're best kept that way.
Thank you. Thank you. Wait. I'm reviewing again the chat box and the Q&A box, and I think that there are a lot of questions being raised, but they really pertain more to matters of domestic law. So I wouldn't want to burden our guests with answering those particular issues, and perhaps that's something that actually another conference of the PBA could deal with. No, these are really issues concerning domestic law and domestic policy. See what there is
I'll
a
just
question
pick up.
though raised by
Sorry, I was
one of our sorry.
after you, please.
Okay. There's a question raised by one of our participants to Justice Carpio, and this is in relation to the ICC case that was filed, the information that was filed, and I guess probably what it would be, what is the best way to frame this would be, what is the progress of this? Could this be considered? Could these proceedings in the ICC, which are based on the wrongs, some of the wrongs that were undertaken that were found to be wrong in the arbitral award, could this be a basis for this ICC case? And what is the progress, sir, on this particular proceeding? This is for Justice Carpio.
Thank you for that. Well, our theory there in the ICC is that the destruction of the marine environment upon instruction of President Z and carried out by his subordinates constitute a crime against humanity because it deprived a huge number of people living around the South China Sea of their livelihood, of their source of food. And because it was committed in Philippine territory, like Scarborough Shoal, and because Scarborough Shoal is Philippine territory, therefore, at that time we were parties, we were still member of the ICC. We could bring this, and of course, this is an individual crime that can be filed against the head of state individually and not necessarily against the state. So the issue there is the jurisdiction of the ICC, because the ICC said, the prosecutor said, the destruction of the marine environment did not happen in Philippine territory because it happened in Mischief Reef, which was declared by the UNCLOS Tribunal as part of the EEZ and not part of the territorial sea of the Philippines. But we pointed out that in the same award of the tribunal said Subi Reef is part of the territorial sea of Pag-asa, which is occupied by the Philippines. And the Chinese also destroyed the atoll reef in Subi Reef. So that's one destruction of marine reef that took place in the territorial sea of the Philippines per the decision of the tribunal, which we said the ICC prosecutor failed to take into account. And also, Scarborough Shoal is part of Philippine territory. We have claimed that since the time of the Spaniards. And the Chinese also destroyed the Chinese fishermen also destroyed the giant clams there, and we pointed out also. So basically, the issue is the jurisdiction. It's still there. We're just waiting for further action by the ICC. Thank you.
Thank you, Justice Carpio. Dr. Plant, you were about to say something earlier.
I was just picking up on a comment. Somebody's made several remarks about joint ventures and so on. And it's an idea that I've seen mentioned a few times before that I wonder what the audience would think of, but of the Philippines creating something like a joint development and protection zone some sort of maritime park that allowed environmental goals and economic goals to be pursued together with neighbours with adjacent and frankly overlapping claims. It's a technique which has been used with considerable success in certain parts of the world, and some other near neighbours of the Philippines have used it. That might be something that would allow solidarity among certain of the smaller littoral states in the South China Sea to group together and perhaps resist the intrusive practices of China and Chinese fishermen.
Yes. That option actually has been raised before, and I recall that Justice Carpio also early on suggested it around 2016, 2017 as one of the things that could be done as part of the implementation of the award. Justice Carpio, could you possibly recall for our audience what the parameters of this idea was at the time?
Yes, I was proposing that the Spratlys be declared a marine protected area, that the claimant states suspend for 50 to 100 years their territorial claim and just declare the entire area as a marine protected area, because the Spratlys are this breeding ground of fish. We have a lot of fish in the South China Sea. It's one of the most productive fishing grounds in the world because of the Spratlys, because the Spratlys are an extensive collection of atolls, and in the atolls, that's where the fish spawn. And so if we protect the Spratlys as a fishing ground, as a spawning ground of fish, then the number one beneficiary will be China, because China now takes more than 50% of the annual fish catch in the South China Sea. So China should agree to declaring the Spratlys as a marine protected area. That was the proposal that we made because the marine biologist, Dr. McManus, who has studied the Spratlys when he was in the Philippines, brought this up in one conference of marine biologists, that if you want to maintain the fish stock in the South China Sea, you have to preserve the Spratlys as a marine protected area, because without the Spratlys, you won't have as much fish as you have now in the South China Sea. Thank you.
Thank you, Justice Carpio. Ladies and gentlemen, it is now 11:15. Now, I would not want to be accused of inflicting cruel and unusual punishment on our guests who are really here with us at ungodly hours, as mentioned earlier. So I will have to bring the Q&A portion to a close. And thank you, ladies and gentlemen. Thank you, Dr. Koo, Dr. Plant, Justice Carpio, for interacting with our audience on the Q&A. Let me just now turn over our proceedings back to Jean. Take it away.
Thank you, Jay. I am reminded of something Justice Carpio mentioned. The battle to defend our sovereign rights in the West Philippine Sea is also a battle for the hearts and minds of the people of the world. Now, when I first heard that, it was, I thought it was outward, right? Letting the other countries be involved. But at this juncture, this seems to go both ways within the Philippines. And as you guys mentioned, in creating this community, the concept of self-help measures discussed here highlights the fight we have now within the country against defeatism or this helplessness, as Jay mentioned. We are also reminded that this is a long haul post-adjudication strategy. So that energy needs to be sustained, and the creativity needed, not just to be bound by what is legal, but also what can be done through the diplomatic service. We truly appreciate Dr. Plant and Professor Who's expertise on this matter in exploring these options, from judicial measures to countermeasures to shameware, and of course to Senior Associate Justice Antonio T. Carpio for leading the clarion call and painstakingly looking for various options available to us. And thank you, of course, to Dr. Batong Bakal for leading the conversation as well. So now, for our closing remarks, we will call on PBA past president and current trustee, Attorney Fina Bernadette de la Cuesta Tantuico, for the closing remarks.
Thank you very much. that we had this morning, and we cannot thank our speakers enough. And on behalf, therefore, of the Philippine Bar Association, the Harvard Alumni Association of the Philippines, and the Philippine chapter of the International Committee of the New York State Bar Association, as well as our very active attendees, may we thank our esteemed speakers, retired Supreme Court Justice Antonio Carpio, Dr. Brendan Plant and Professor Julian Koo for their very incisive presentations and for generously lending their expertise to this webinar conceived in response to recent developments concerning the West Philippine Sea, a pressing issue not just of national but international concern as well. Thank you too to our moderator, Professor Dr. J. Batong Bakal, and our very fabulous MC, Attorney Jean De Castro, for ably and expertly shepherding this morning's discussion. I dare say that true to its calling, the Philippine Bar Association has once again made history with the wealth of information derived from the expertise of the speakers in this morning's webinar. We truly hope that this modest undertaking, which has been very instructive and illuminating, has provided our policymakers with the information necessary for them to be able to chart the strategy needed to address the pivotal issues relating to the enforcement of the 2016 arbitral ruling and the remedies available in its implementation. Lastly, may I acknowledge the members of the PBA's Webinar Organizing Committee, composed of past PBA President Pope Solis, current Association Secretary and Trustee Ian Malilong, Attorney John Molo, past President of the Harvard Law School Alumni Association, as well as Professor J.J. Dicini, its incumbent President, PBA's Office Manager, Ms. Jing Osias, and the rest of the IT support group led by Ms. Vicky Solis, without whose help this webinar would not have come to fruition. Once again, thank you to all, and mabuhay